Good morning and welcome to this morning's panel. My name is Yeni-Komshian, and it is my great honor to moderate this panel on universal jurisdiction over serious international law crimes and atrocities. We have a wonderful group of panelists today. Sitting next to me is Anahit Muradyan, who is a CFTJ Law Clinic alumni from 2021. After obtaining her bachelor's degree in political science and an LLM from AUA, she decided to join CFTJ and make her own contribution to the collection and preservation of evidence in furtherance of efforts to restore the rights and peaceful development of Nagorno-Karabakh's indigenous Armenians. We also have with us today Dr. Maria Armoudian, who is a senior lecturer at the University of Auckland in New Zealand, founder and producer of the Scholars Circle radio program, and author of 3 books, Lawyers Beyond Borders, Advancing International Human Rights Through Local Laws and Courts, Kill the Messenger, The Media's Role in Fate of the World, and Reporting from the Danger Zone, Frontline Journalists, Their Jobs, and an Increasingly Perilous Future. She has published widely on human rights, environmental politics, communication, and good governance. Before coming to the University of Auckland, she served as a commissioner in the city of Los Angeles for 6 years and worked in the California State Legislature for 8 years, working on many issues ranging from environmental sustainability to good government and corporate reform. In addition to her academic publications, her articles have been published by the Washington Post, the Columbia Journalism Review, Psychology Today, to name a few. I'd also like to thank Dr. Armoudian for traveling more than 44 hours from New Zealand to be with us today. So your presence here means a lot. Thank you so much. I'd also like to thank our panelists who are appearing over Zoom. We have with us Dr. Gurgen Petrossian, who is a lecturer at the International Criminal Law Research Unit at the University of Erlangen-Nürnberg and chair of the German Armenian Lawyers Association. He holds a master's degree from Heidelberg University and a bachelor's degree in law from Yerevan State University. In 2018, he completed his PhD from the University of Erlangen-Nürnberg. His research interests lie mainly in international law, international criminal law, business, and human rights. He has successfully led various funded research projects in international criminal law, including projects Victims Before International Criminal Court and Length of Proceedings in the International Criminal Court. We also have with us Rajika Shah, who is the Deputy Director of the Center for the Study of Law and Genocide at Loyola Law School, where she also runs the Loyola Genocide Justice Clinic. Prior to joining Loyola, Rajika litigated international human rights property restitution cases on behalf of Armenian and Sudanese genocide victims, indigenous groups, and religious ethnic minorities. She has represented plaintiffs in numerous complex and high-stakes disputes against foreign sovereigns and commercial entities, both at the trial and appellate levels. She also represented Libyan terrorist hijacking victims before the U.S. Foreign Claims Settlement Commission. Rajika has extensive research experience through her work with the Oxford University Press and was instrumental in building and developing Oxford reports on international law, the most comprehensive, fully indexed and searchable database of international case law and scholarly commentary across a wide variety of international law subjects. While interning in the U.S. Department's Office of War Crimes Issues, Rajika traveled as part of the official U.S. delegation to the Special Court of Sierra Leone and the International Criminal Tribunal for the former Yugoslavia. She also completed internships at the British Institute of International and Comparative Law and the Executive Office for Immigration Review, and externed for the Honorable Terry Hatter at the U.S. District Court for the Central District of California. Rajika received her LLM in Public International Law with distinction from the London School of Economics and Political Science. Welcome to our panelists, and I will hand the floor over to Anahit. Thank you, Anahit.
Thank you, Lori. Good morning, everyone. What I would like to present you today is based on my research on the state responsibility for the recruitment, use, financing, and training of mercenaries by Azerbaijan in contravention of its legal obligations under the UN Mercenary Convention. As we all know, on September 27, 2020, Azerbaijan, with Turkey's active support, launched a military attack against the Republic of Artsakh. According to several studies, investigations, reports provided by international human rights organizations, statements of foreign government and international media, the presence of UN mercenaries in Azerbaijan and in Artsakh conflict zone has been established. Under public international law, there are three major documents which regulate mercenary activities. OAU Convention for the Elimination of Mercenaries in Africa, which deals with issues of mercenaries, but in the African context. Additional Protocol 1 to Geneva Conventions, and UN Mercenary Convention, which is also called International Convention Against the Recruitment, Use, Financing, and Training of Mercenaries. Azerbaijan and Armenia are parties to the UN Mercenary Convention. Hence, they have undertaken obligations not to recruit, finance, train, and use mercenaries. Azerbaijan's breach of the aforementioned obligation has been established and has become public knowledge. According to this information, Azerbaijan used those mercenaries in Artsakh, and this information has already been proven. And the available evidence will likely be sufficient to establish and meet the jurisdictional evidentiary requirements of ICJ. Now, I would like to refer to ICJ's jurisdiction, how ICJ can take this case. And in this case, having sufficient evidentiary basis for submitting a claim to ICJ, there is a need to meet the jurisdictional requirements of the court. In this case, there may be the following issues of major concern for meeting these jurisdictional requirements: whether there is the consent of the parties to ICJ's jurisdiction, whether Armenia has a standing before the court and is the right claimant. And the third one is whether Armenia's late ratification of the UN Mercenary Convention can be the basis for the rejection of the claim. As to the consent of the parties to ICJ's jurisdiction, it should be noted that this consent should be established. And here we have a compromissory clause stipulated in the UN Mercenary Convention, which provides a mechanism to refer to ICJ. And neither Azerbaijan nor Armenia has made any reservations with respect to this compromissory clause. Therefore, both of them have consented to ICJ's jurisdiction. However, the court provides employing other dispute resolution mechanisms such as negotiation and arbitration before applying to the court. As to Armenia standing before the court, there may be an argument that Artsakh is affected by the breach of the convention and not Armenia, and Artsakh, being an unrecognized state, will not have standing before the court. However, there can be two counter-arguments in this regard. First, assuming that Armenia had a substantiated title with respect to the territories of Artsakh before the 2020 war, it could be considered as a state specially affected by the breach. However, the court may be reluctant to refer to the title of Artsakh where, in a case where the subject matter is a different issue. Therefore, the second counter-argument can establish the basis of Armenia standing before the court. In this case, Armenia, being a third party, may invoke Azerbaijan's responsibility, as the obligations under the UN Mercenary Convention are obligations erga omnes partes. It means Azerbaijan owes those obligations to all the state parties to the UN Mercenary Convention. As to the temporal aspect of the late ratification of the UN Mercenary Convention, it should be noted that, again, under the UN Mercenary Convention, the obligations are not reciprocal. It means they are not synalogmatic in nature. The binding effects are collective and cannot be separated into bilateral elements. Therefore, even though Armenia didn't ratify the UN Mercenary Convention at a time when Azerbaijan acted in contravention of its legal obligations under the UN Mercenary Convention, it should not have any legal consequences, as in any case, Azerbaijan had obligations it should not have violated. Thank you.
Thank you so much, Anahit. And now I will hand the floor. Yes, can we get the PowerPoint up on the screen? And I'll hand the floor over to, if you press the button.
This one. Okay, very good. Paref says, Shadurachim for Hossam, thank you so much. I am so happy to be here. It was worth every bit of those 44 hours and all of the disasters and crises that I had to endure to get here. And while I was on the way, my students were taking their final exam and they're all mad at me. But that's okay. So I want to talk a little bit about universal jurisdiction, a little bit about how its history and its development and where it is today in use, because it is being used quite a bit more today than it has been historically. And so if you could go to the next slide. So people think that, for the most part, scholars are thinking that it really originated from the jurist Grotius, Hugo Grotius, the Dutch philosopher. And they thought at the time that piracy was the thing that they were most concerned about. And universal jurisdiction, the idea is that some crimes are so heinous and so, again, oh, I can operate it myself with this? This is fabulous. That's even better. That crimes are so heinous and so counter to what we are as humanity that they should be prosecutable anywhere. And that was an idea that Grotius had put across, but also it goes back to Cicero. He had also talked about the concept of universal jurisdiction. And so, as most of you know, jurisdiction is usually just what the court can hear, what its purview is legally. But in the case of universal jurisdiction, any country can prosecute certain crimes, crimes against humanity, genocide, torture, war crimes, if they have certain enabling legislation, and that's one of the issues. Is this working? Nope. This one? Aha, voila. And then I'll break this so I can see where I am. So there are several instruments that actually enable it. For example, the Torture Convention is one of them. But I made a list here so that if anybody would like at least a place to start, you can see it goes all the way back into 1907, Article 3 of War on Land of the Hague Convention 4. 1966 again, Article 2, the International Covenant on Civil and Political Rights. 1984, the Convention on Torture, and I'm going to talk a little bit more about that, because that's one of the areas that I have kind of examined civilly as well. Then, of course, the UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, the Rome Statute, which established the ICC, and then you can see the others here as well, all the way up to 2006, again, enforcing the ideas of universal jurisdiction, even though they don't specifically say universal jurisdiction. Oops, I think did I go the wrong way? Nope, this one? Aha, voila. So, okay, so I'm doing two at once. I'm having to remember which ones are which. So I just pulled some of them out specifically from the Torture Convention, some of the language, so that you could see just kind of what they say. And what is so heinous? Torture is clearly one of them. And the convention, for those who have signed on to the Torture Convention, requires each state party to take effective measures to prevent, but also to make sure that the offenses are punishable, with penalties that are appropriate for torture, and that ensures that the victims of torture, the survivors of torture, get adequate compensation, full rehabilitation, if possible at all. If they're dead, then the people who are their survivors are also to get compensation, rehabilitation. What's required? So you absolutely, each country that is going to invoke universal jurisdiction, see, jet lag and no coffee makes you fumble up your words. I actually had a little bit, I'm lying. It was just an excuse. No, of course, thank you. I actually would like some, but not yet. So the countries that want to invoke universal jurisdiction must have legislation that clearly says that they are going to take up a universal jurisdiction. And there are several that have already. We can talk about some of those. Look, you guys, it's not just the enabling statute, which are sometimes hard to find, by the way. The United States ones, which I'm going to talk about a little bit, it was really an obscure statute that a lawyer found that was in its very first Judiciary Act, and then they used it civilly. So that's the creative advocacy part, which is the second bullet point. It's committed advocates who find ways to match the facts with the statutes and go looking for those statutes that can say something that invokes it. That, of course, it's the political will, and that's key. There are lots of places that have universal jurisdiction. Spain was one, and it prosecuted Augusto Pinochet. But then after that, the political will sort of vanished, and they narrowed the capacity for the country to go after some of the war crimes that they wanted to. Then, of course, as you've heard from other panels, you need the witnesses, the evidence. And some countries require the accused to be there. And again, that depends on what their enabling legislation says. Some can do it in absentia, in absence. Criminal law it's clearly speaking to criminal law, but there are also civil applications that have been used in some countries. And these were the ones that I just started to mention. Of course, Eichmann, as we know, that's kind of one of the very early post-World War II efforts. They prosecuted him. They found him in Argentina. I think one of the other guests is going to speak about that, so I won't go into it. Pinochet, which I mentioned in Spain, and now the German, not just Germany, but Germany's doing the really big cases around the Syrian war crimes. And I think our other panelist is going to talk about those, so I won't. I'll talk then a little bit about the civil development. So the civil application, even though universal jurisdiction is about crime, the advocates in the United States, especially the guy at the top, who is Peter Weiss, who is now 95, I think, but he was this really creative Holocaust survivor who was sort of steeped both in Cicero, but also in the civil rights movement in the United States. And I think it's really important to think about the civil rights movement in the United States in terms of civil development, because those lawyers found ways, along with the survivors of the abuses in the U.S., to use the courts as one of the tools to advance rights and reparations. Rights and reparations. And they did this through civil litigation. And Peter Weiss, was looking for the statute. And what he did is he stumbled across this, very first laws in the United States, the Judiciary Act, that gave the court jurisdiction. And all this one statute said, it was called the Alien Tort Statute, was that the courts had jurisdiction over cases in which there was a tort that violated international law, the laws of nations, that they could look at it even if the survivor or victim of the tort was an alien, and that it occurred on alien land, and that the violator was alien, so foreign. So they call that foreign cubed. So Peter represented the father of the other picture, the young man there, that's Juelito Florga, which became the turning point case. And Juelito was tortured to death in Paraguay by a Paraguayan, and he was 17 years old. And Peter represented his father in U.S. courts, and they eventually won a case against the Paraguayan military man who tortured Juelito to death, and got a $10 million judgment against him. Also got his deportation from the United States at the time, which they appreciated doing. He happened to be there, so they were able to get personal jurisdiction over him by serving him the papers. That case spawned a movement, because that's kind of how the U.S. civil rights movement worked, where once the law was established, because it's a common law country, other lawyers started representing other foreigners who had been violated in these different ways, whether it was torture or a massacre or a disappearance, because there were all these Latin American cases in which people were being disappeared as well as tortured. And they were winning these these cases in U.S. courts and a lot of big judgments. They also expanded it into corporations, where they started suing the corporations and getting even bigger judgments, and they could collect on those. Whereas on these individual ones, it was hard to collect the money. So let me see. Then the other great thing that happened in the United States was that these two legislators, who are now dead now in Congress, passed a law to not only affirm the Alien Tort Statute, but to expand it, and that was called the Torture Victim Protection Act. And again, what it did is it said, if you've been tortured anywhere in the world, you have access to American courts for civil litigation, right? And it was for two things, for torture or for extrajudicial killing, under the color of law. Excluded corporations. That was the only kind of thing that I think they maybe should not have done. But so that is still on the books, even while the U.S. courts, the Supreme Court, has become so conservative that they've narrowed the original statute, the Alien Tort Statute, so that now it has to touch and concern the United States to be able to use it. Now, in the European courts, what had happened is Peter Weiss was also working with Wolfgang Kalek, and they together founded the European Center for Constitutional and Human Rights, which is the NGO that has been really at the core of these German cases that are prosecuting war criminals from Syria. And but there are other human rights organizations and lawyers throughout Europe that have been involved, of course, but the ECCHR has been really vital in these cases, in coordinating them and seeing that they move forward. So Trial International is one of the NGOs, and this is just their count. Every year they do a count of universal jurisdiction cases, and they have counted here. You can see it's been about 120-ish UJ cases over the last few years. So my book, Lawyers Beyond Borders, came out in 2021, but the last report I had was from 2017 then, and it was about the same. So it's kind of steady at the moment. And you can see how many cases: 34 war crimes, 66 crimes against humanity, sexual violence, and genocide. So this is also from Trial International survey that they do. They've counted that it's happening in 16 countries for allegations in 22 others. These are the countries that have them. By the way, there are other countries that have universal jurisdiction statutes but don't currently have cases. Australia is one of them. Big Armenian community there too, by the way. So just worthy of keeping that in mind when we're exploring what the options are for Armenians in Artsakh, is that there's a very big Armenian population in Australia. They have the enabling statute. I don't think they have any cases. I'm not a lawyer, just as a background. I'm a political scientist, so you have to work with lawyers on that. Right. So the other thing, I think I have to see with my glasses on this to remember. Oh, so the other thing that is not necessarily universal jurisdiction, but has been happening all over the world, is that countries are holding often their own corporations accountable for being involved in war crimes types of activities or other human rights violations. And these are just some of them. I won't name them for the sake of time, but anybody's welcome to take a look at the slides, or I can email stuff over to you as well. Some of them are for their extractive corporations, mining companies, oil companies that then violate the indigenous populations, either slavery or torture or killing, in order to draw those minerals. But others are for like surveillance types of technologies that are being used to find and track and kill. So these are other cases that can also possibly be used. I want to talk a bit about who opposes universal jurisdiction, because a lot of people do. That's Henry Kissinger. Yes, I thought I would get a kick out of that. But he obviously opposes it. And the ideas, so remember, these are just ideas, and it's always a battle of ideas when you're dealing with law and justice, right? Even law and justice are ideas. But they argue in favor of sovereignty, right? Sovereignty being the end all. And there is a place for sovereignty. Obviously, we want, our countries to have some say, but they don't want sovereignty to ever be, placed under jurisdiction. And so that's one of the oppositions that has come forward to it. They also have concerns about civil society being able to interfere with foreign relations between heads of state and that sort of a thing. And they talk about this. And then, of course, they say judicial tyranny, which, whatever. Sorry, I shouldn't be so... Oh, that was what I meant to... I didn't move that one, did I? So there you go. There's your man, Henry Kissinger. That's what... So why other opposition? Obviously, there's a bit of hypocrisy among some Western nations, right? And there's a sort of unequal enforcement of human rights. A lot of times these cases are happening in the West, in the Western world, but they're prosecuting people in either the South or in the underdeveloped, but not their own, right? So one of the things that the ECCHR was founded on, it was founded because of the Bush administration in Iraq. And Peter Weiss and Wolfgang Kalek had gotten together and said, we want to hold United States people accountable for the war crimes. And so they were using the German universal jurisdiction statute to try to bring Donald Rumsfeld to justice. And the prosecutor declined it in Germany. Principle of complementarity, which is, as Peter Weiss would say, a ridiculous idea. But that was the kind of founding force of the ECCHR, but obviously they were never held accountable. So there's this concern about jurisdictional imperialism, the West over the rest. Finally, I think what I want to say is that the United States it advanced the civil ideas of using universal jurisdiction for civil actions and for rights and reparations, and then the courts tore it down. But today, now, the Congress is trying to fix that. Let's see if it happens. It's Senator Durbin and Sherrod Brown, who have introduced an affirmation to the Alien Tort Statute to try to restore its capacity for any survivors, as well as to go after corporations who are part of the problem. Simultaneously, because of what's happened in Ukraine, now Republicans are interested in the idea of universal jurisdiction. And so Durbin has now gotten agreement from some of the lead Republican senators to alter the War Crimes Act and to have some version of universal jurisdiction in American courts, which then, if they do get that through, can also be used for the cause of Artsakh. So I think what I want to conclude with is that rights, human rights, civil rights are not gifts. They are not givens. These are man-made creations. Some say they're God-created, but even if they're God-created, they are not upheld without all of us. Not only subscribing to the ideas, but taking the actions to ensure that they are sustained. But it also really requires really good lawyers and advocates to creatively put these things together in order to make the cases that then can set the precedents in this way in order to build the fabric, because the fabric of rights is so important, and it is us, it is people who do that. Thank you.
Thank you so much. I appreciate it. Now, if I'd like to invite Dr. Petrossian, if we can bring his Zoom up to the screen. And while we're bringing that up on the screen, if you have any questions, there is an opportunity to write down your questions. Okay. Okay, welcome, Dr. Petrossian. We can hear you, but we can't see you.
Okay, I'm still in the permission to start my video from the host. Can you hear me? Can I hear?
We can hear you.
Okay, perfect. But I think I still need the host to allow me to start the video.
Okay.
It's on the host side.
Okay, we will work on that right now.
But as soon as I can maybe start with my presentation by sharing my screen.
Okay, we're able to see your screen.
Excellent. Good. So good morning, everyone. This is, of course, an honor for me to be present here to this very important conference organized by you. And this is very. I think this is very important in the sense that all stuff which we are going to do and is important to bring people to accountability for the commission of international crimes. What I'm going to speak today concentrates mostly on three aspects: on accountability for international crimes, what are those ways of bringing accountability. Then I will concentrate also on the prosecution under German jurisdiction, and then I will look also what are the possible alternatives ways or legal civil litigation ways, as also was distinguished, as was also presented by other panelists, are actually available to bring the war crimes before the justice. And then I will conclude with some few recommendations for the future. So while discussing the international criminal law, we have to think about three different layers. I think this way would be better. The first one is the prosecution before International Criminal Court. The second one is the internationalized mechanism or instrument. And the third one, as already mentioned, the universal jurisdiction or the national court, domestic jurisdiction. So while considering International Criminal Court, during the war, we had some discussions with my colleagues. What are the reasons why there is no application of state referral from the side of Republic of Armenia or Republic of Artsakh to make some kind of to have another eye on the conflict? But these kind of discussions were then frozen, and this topic was somehow closed. However, at this moment, considering the situation on the ground for today, I do not see really any obstacles for the Republic of Armenia to apply or to make a state referral to the International Criminal Court, considering in mind that some Azerbaijani troops are in the presence in the sovereign territory of Republic of Armenia, and the joining the amendment, the Kampala amendment on the crime of aggression would be much more beneficial for this situation. On the other part, the state referral by the Republic of Artsakh is another interesting point, which and in International Criminal Court there is already some kind of established practice in regards to situation in Palestine or the membership of the Cook Islands, which are not a recognized state but still a member to the International Criminal Court. I think these topics should be somehow still discussed in the by the authorities to see the legal and political consequences of being a member to the International Criminal Court. Not joining to the ICC before, I can imagine the political reasons behind or other issues resulting from the membership, but at this moment we have pretty different situation. Furthermore, the internationalized instrument. You see that there are lots of examples of bringing or making international or internationalized mechanism usage, or making usage of those international mechanisms for the conflict resolution, for example, such as the Kosovo Special Chamber, Special Criminal Court in Central African Republic, or for example, today there are also discussions within the European Union to create something alternative to make accountable the criminals of the recent conflict between Ukraine and Russian Federation. I don't really see that this is going to be a near future for the conflict of our conflict. However, we still have to keep in mind that this kind of mechanism and instruments are still possible to bring war criminals before the justice. And of course, the national courts, the domestic jurisdiction, and of course, universal jurisdiction, which was already presented by other panelists. However, we have to think about here that the universal jurisdiction should be divided into two parts. One is the pure jurisdiction, pure universal jurisdiction, which means independent of any connection to the country, the jurisdiction may still apply. However, not every state is really happy to apply this universal jurisdiction from its pure perspective, but they always try to find some kind of territorial connection. So, for example, if the suspect is present in the territory. So let's look into the German practice. What exactly allows the German jurisdiction to us how we can apply the universal jurisdiction in our particular case? So in Germany, we have the German Code of Crimes Against International Law, which gives us a very huge scope of application, and like this act shall apply to all criminal offences, even when the offence was committed abroad and bears no relation to Germany. And you can see that it of course covers the crimes against humanity, the crime of genocide, crime of aggression, and also war crimes against persons. But as you can see, and this is the war crimes against persons, as this is one of the biggest part of our work, what we have done, you can see that the German code does not make a real difference between international conflict and national conflict. It distinguishes in a similar, it does not distinguish different character of the conflict. And what is very interesting here, that since 2014, as it was already mentioned, the German government and German prosecutor office is very active in identifying the criminals from foreign conflicts. Syrian conflict was one of the most triggering aspects of bringing the cases before the court, because many of refugees were staying in Germany, and they were identified by their smartphones when they, for example, presented during the asylum interview why they are actually applying for asylum. And during that interview, the handies and smartphones were actually shown to the authorities, where many of the pictures of the perpetrators and also war crime scenes were actually disclosed. Many of the cases, or let's say not that much popular cases in Germany on the universal jurisdiction basis, are referring to the number 9, treats a person who is to be protected under international humanitarian law in a gravely humiliating or degrading manner. This is one of the important, and maybe also one of the modern jurisprudence established by the Swedish court and also by the German court, because here we have for the first time that the post-mortem rights of the protected person is also considered, or violation of the post-mortem rights of the protected person is also considered to be a war crime, or is qualified as a war crime. So, for example, if the perpetrator humiliates the body of the soldier, of the dead body of soldier or even civilian, and makes photos, selfies, or otherwise shows before the camera how he disregards the dead body, is still considered to be a war crime. And most of the evidence which was presented here, and most of the proceedings which are before the courts are connected to that issue, because this is one of the most important source of evidence which the authorities can really rely on in Germany. You can imagine that the evidence is most problematic issue in the case of universal jurisdiction, because the prosecutor should rely only on the stuff which is on their hand. They cannot travel to the conflict scenes. They cannot really go to the conflict scene to make their investigation in situ to see what is actually happening, because of various reasons, because of the language, because of the conflict situation. So they have to rely they mostly rely on the evidence which is brought by the perpetrator to the border, or for example, there are lots of victims who are presenting this kind of evidence to the prosecutor. Okay, this is from the material side. Let's have a look on the procedural law. What do we see? Even if the material law says us that there is a universal jurisdiction in the poor perspective, from the procedural law, the German authorities are bound. Well, it's in their decision to not to start the investigation. These are, for example, the grounds which allow the prosecutor to dispense with the prosecuting act. For example, if the suspect is not in Germany, if no German national is suspected, if the offense was not committed against the German national, and if no suspect is or is expected to be staying in Germany. Most of the one of the important cases which was brought before the German court is the genocide case of one Yazidi girl who was killed in Mosul. The guy was in Greece, and he applied for an asylum in Greece. But then, as soon as the German authorities identified that he is connected to the genocide case, which was also running here in Germany, they asked for extradition the suspect to Germany in order to try here in Germany. So this is also which works between the European countries, this kind of cooperation in the criminal cases. But as you can see, this allows the prosecutor it's in discretion of the prosecutor when it may start a proceeding against the person or when it cannot start. This is very important, however, but let me come to the next point. Let's see what exactly happened to the Artsakh conflict and to the criminal complaint which the German Armenian Lawyers Associations brought before the prosecutor to start an observation and then to investigation into the case. So what we have done, we have collected, thanks to our colleagues in Armenia, mostly to the path of law and other NGOs who could give us some information or testimonies from the victims, direct and indirect victims, what exactly happened on the ground. We started to do our own investigation in identifying the victims and the perpetrators, because as you may know, there were also a lot of videos and footages which were posted during the war through the social media platforms such as Telegram, TikTok, Instagram, and we started to collect them. In 2020, we filed our first criminal complaint, and then we updated as soon as we collected more and more evidence and footages from the social media platforms. We applied it, and only last year, in October 2021, we filed a huge file and submission about the testimonies, about our own investigation to the public prosecutor. And we received a reply that this is under observation, but I will come to that point a bit later. So how we did, we tried also to make a categorization of war crimes committed. The first one, as you can see, the categorization is based on the first contact to the victim. This allows us to, by those perpetrator circles, and then we can just go deeper and deeper in the chain of command responsibility. The first one is the first contact in the battlefield, when the victim is contacted by the special unit, the forces, by the special forces, or I don't know, by the state border service or other army corps. And as you can see from the map, the main crimes which could identified by our side were perpetrated from the southern part of Artsakh. And you can see there is a line which goes in direct to the city of Shushi. You can see that this is exactly the path or the advance route of the Azerbaijani soldiers, and they were committing war crimes exactly whenever they were entering in the cities or villages. Another part, or another second phase of the criminals or criminal cycle, is those who were transporting the prisoners of war to the capital city of Baku. And this circle is of course much bigger because we have here not only the state security service, military court in Baku, we have the prosecution office, we have even the personnel of the detention center, prison facility. So these are the two circles which were concentrating in our criminal complaint. So what kind of evidence we have received and we've collected? We've collected the testimonies of indirect victims, findings of open source investigation and reports. One of the important point, what I want to mark here, is the following military pass of one of the soldiers who was present in the Hadrut city, and he was publishing this kind of evidence pretty proudly in the social platforms, where we can see exactly the name of the commanders. And this allows us to find out, of course, those personnel who was present at that moment when the crimes were happening in the city of Hadrut. We can see the commanders, and according to the chain of command responsibility, which is another part, very important part in the international criminal law, that if the direct perpetrator is not punished, or is not, if the war crime is not prevented, suppressed, repressed, or punished by the superior, then superior is maybe still held accountable for its omission on the international criminal level. However, in Germany, we have not only an omission, but also a commission. So the person, the superior, may be here in Germany held accountable not only for not preventing as an omission, but also as a commission of the war crime. This is very important, very important moment in the criminal law in Germany, which allows us to bring the superiors also to the German court for not punishing the crimes if they were not directly involved in the crime scenes. So what is the next steps? What we have to do? We need more evidence, and this evidence which is collected is, of course, should be centralized. I see that there are some different spots where the evidence is collected, but they are differing from its purpose. For example, one collects for bringing the cases before the European Human Rights Court. One collects the evidence for other purposes before the Court of Justice. But I think this should be some kind of centralized and so maybe a central database should be created for this kind of evidence, so we can use it for the universal jurisdiction cases. Another important aspect is that the perpetrators who are identified, they should be tracked through social media platforms. We see that this kind of tactic, the strategy, is also used by Bellingcat today, and also in the Ukraine and Russian conflict, that those perpetrators, they are proudly performing in the TikTok, in I don't know, in every social platform, and this is another trick to track them, to screen them when they are entering the European borders, when they are entering German borders, so we can bring the cases against them. And of course, in the case of individual complaints, a more strategic approach should be used. The criminal complaint which we brought before the German court, the same action was done in Sweden and also in Argentina. Because of their good practice in that field. What I want, as I still have some time, I want to make your attention also on the other aspect, as also was mentioned by my colleague. The accountability of the international corporations is another important aspect in the universal jurisdiction cases. So I want to make your attention on two particular situations, on the past cases and on the future cases. Lafarge case is another Trafaret example of bringing international cooperation before the court. There are lots of other international corporations which were involved in Azerbaijani government and in Azerbaijani business. And if we can find any connection between the complicity between these corporations and the War Crimes Committee, so international corporations may be held here on the national level accountable for their participation in somehow directly or indirectly in the war crimes. Of course, this needs a lot of litigation, a lot of preparation, and a lot of evidence. However, this is also one important point which we have to use for our cases. Future cases, which means accountability of civil litigation based on the UN guiding principles on business and human rights. Again, Germany here is one of the first or those who try to bind their corporations, their companies, to respect the human rights when they are sourcing in different countries or even in the conflict regions. We see what happens exactly at this moment with the Uyghur region in China, that the corporations are bound to respect or just to come out from the conflict region because of the mass violation or mass human rights violations in that particular region. And this is a trend which is going to bind all international corporations, not only in Germany, but also in the European Union. There is a huge discussion that also the guiding principles on human rights, business and human rights also should cover all European countries, and they have to respect it. So the idea is, if there is a connection between the violation of oppression, Armenian population of Republic Artsakh, or somehow by the international corporation, they should be brought before civil courts on their domestic level. On the other side, now I would like to conclude. I know that I have less time. Just to make again some thoughts. What are the topics that we have to think about? Maybe one of the things is the ICC membership, which should be maybe reconsidered again, and particularly the Kampala Amendment. Furthermore, the universal jurisdiction cases, a strategic and centralized, be somehow streamlined from not only that NGOs do that, but also a streamline is much more needed. Any evidence, even small, in the open platform should be collected as soon as possible, because there is a huge amount of evidence which is still in the social platforms, but we can lose there day by day, but not collecting them. Even small shootages, like 2 seconds of shootages, are a leading evidence for the universal jurisdiction cases. Syrian Archive and CFTJ, which were mentioned here in the panel, are the best examples how this kind of evidence should be collected, documented, and then brought before the court to be an admissible evidence. Furthermore, the perpetrators should be tracked through social platforms. This is another point which I want to make your attention on, that we have to look for the perpetrators. We have to track them to see when they are entering the European Union borders or the German borders. Other domestic means of accountability of legal path should be reconsidered in respect of Artsakh war. This was a war, and the war is the destruction. And only just ignoring the consequences or just ignoring the thing what happened, we cannot ignore that, because the war may still repeat. We have to find the courts where we can raise those issues through litigation. And of course, very important point, universal jurisdiction is not a quick tool. We cannot have a quick result through universal jurisdiction. It is forward-looking instrument. Thank you very much for your attention.
Thank you so much, Dr. Petrossian.
I'm going to break the rules. Could I just ask a quick question?
Of course.
Dr. Petrossian? Can you hear me? We're going to get the microphone. All right, can you just...
Dr. Petrossian, there's a question for you.
Dr. Petrossian, this is Gassia Abkarian. Sure. Hello. This is the first time I've actually seen you, but I know the work you do because CFTJ works with you. Here's a quick question. Universal jurisdiction, would you not prefer it over ICC? It seems like ICC could be decades and decades before anything can happen. I just would like to hear which direction would you want us to focus on?
Very good question. I would bring an example of Rohingya minority Myanmar. I think that what they did on the political level was very, very effective to raise the conflict of Rohingya and Rohingya minorities in Myanmar. So what they have done, they brought a case before the International Court of Justice on the state responsibility level. They could convince the Gambian Minister of Justice to bring a case against the Myanmar before the Court of Justice. This is a hilarious thing. At the same time, they could convince the prosecutor to bring a case through Bangladesh before the International Criminal Court. At the same time, they started launching cases in Argentina, in Australia with unsuccessfully, but in Argentina successfully. Recently, the court decided to start an investigation on the Rohingya case. So using all instruments, all legal paths are actually an advantage. I don't see that one is less advantage. It's all instruments are needed on the political side, of course. I could answer your question. But on the other aspect, of course, what we have to think about that International Criminal Court is a complementary instrument. It means like all member states are bound with the complementarity principle, and as soon as they have the war criminal on their ground, they should start investigation. They should punish the perpetrators within their domestic jurisdiction, because ICC is only comes into the game or into the play when there is no prosecution on the ground.
Could I ask you one other question? You spoke about POW treatments and transportation. All right. When you filed on, I believe you filed on behalf of the POWs in Germany, correct? So did you need to identify? No, you have not.
We filed in response from the German Armenian Lawyers Association to pointing out that the war crimes were happening, and of course, Siyanush Sahakyan is also one of the most important, who has the connection to the indirect and direct victims. So these testimonies were presented to the German federal prosecutor.
I see. I guess my question is, one of the problems we have, because CFTJ does collect very specific testimonial evidence with regards to POWs, and we have a very hard time getting anybody to identify actual names of any Azerbaijani perpetrators, whether it's at the first level, second level, or above. Now, I do know State Department has information because I hear names, but to connect those higher level names that are related, that come from Turkey, where the mercenaries were recruited, that doesn't give us the direct perpetrator. So are you successful in identifying actual perpetrators in the transportation and the torture of POWs?
Yeah, very good question. Direct perpetrators is always a dilemma to find out who exactly the direct perpetrator is. You can imagine the corps or the units who are present there, they have a lot of personnel, huge amount of people involved in the area. So who exactly that person is a big question. However, as I presented you, the circles, the perpetrator circles, this is our first point or first leading aspect, how we can go deeper into the chain of command responsibility. One important point, why we are not concentrating on the high level high-level perpetrators because they are still having immunity before the national jurisdiction. So as soon as they travel to Germany in their own capacity, it will be a huge obstacle to bring them before the justice. But the direct perpetrators who are out of the service, they can still be held accountable before the national courts. In identifying the direct perpetrators, we could identify some of them, and we're also bringing another case at this moment to the federal court, federal prosecutor. But I think we'll still keep it confidential. But we are working on working, of course, on the direct perpetrators to identify who exactly they are and to track them. But I think alone, it will not be possible to do. I think we have to join the forces here.
I have one more question. I will not. This is the session that I think I've been waiting for. Sorry. So, Ms. Armoudian, I have a question about the Alien Tort Statute because you touched on this for a little bit. Does it need personal jurisdiction?
I think the U.S. courts have demanded personal jurisdiction, but I think that right now, the better bet when you're talking about individuals is to use the Torture Victim Protection Act because of how the Supreme Court has narrowed the application of the Alien Tort Statute at the moment, where now they have put in limitations that it has to touch and concern the United States, and this conflict doesn't. But the Torture Victim Protection Act does not. It is intentionally extraterritorial. I am never going to try to do a conference after traveling 44 hours the next day again. I'm not always this inarticulate.
You just, on the Torture Victim Protection Act, do you have success stories?
Do I have?
Any success stories?
Oh, gosh.
Any success cases that have set precedent for us to follow?
There are so many. I don't even know where to begin. Yes. Can I just get those to you? Sure. Yeah. Okay.
Okay. At this time, I'd like to invite Rajika Shah, for time. If we can get Ms. Shah on the screen, and we'll have some more time for questions at the end.
Can you hear me?
Yes, we can hear and see you.
Okay, great. Let me share my screen. Okay. Do you see the slides?
Yes, we can see the slides.
Okay, great. So first, of course, I want to thank you very much for the opportunity to come and speak at this conference, although for me it's virtual. But hopefully, I think this is a fantastic initiative by CFTJ. Hopefully, it's the first of many. I'm very sorry that I'm not able to be there in person, particularly because, as the moderator mentioned, I have litigated so many of the Armenian genocide cases in the United States, and I have long experience with the Armenian community, many dear colleagues and friends, including some of the organizers, and I have a lot of warmth and affection for this community. So thank you very much for the opportunity to come and speak here. And hopefully I can be half as eloquent as my boss, Stan Goldman, was yesterday. So I think both of the two previous panelists have actually done a very good job describing sort of the basic contours of universal jurisdiction and some of the challenges. So I'll try to limit those parts of my talk that had planned to talk about those things. And I think maybe one of the things I want to do a little bit more than I had originally planned was contextualize a little bit how the domestic and international jurisdiction sort of work together. And if we can kind of take a step back a little bit, what I would first say is, why are we thinking about universal jurisdiction at all? Why are we even talking about it? Most people, their eyes turn to the International Criminal Court first when they think about international accountability for atrocity crimes. But I think one of the main reasons that universal jurisdiction has, I think it's probably overstating the case to say exploded, but it is increasingly being looked at, particularly in European countries. I think in large part because many perpetrator states are not parties to the ICC. States on whose territory atrocities occur and states whose nationals are perpetrators are not parties. And so at the international level, that really leaves these days no forum at all. There have in the past been some context-specific ad hoc or special courts that have been set up, but there are fewer and fewer of those. And so, as the first speaker mentioned, creative lawyers have been thinking about, okay, well, if the ICC is not an option, where else can we go? And so domestic courts, there's been this kind of return to looking at domestic jurisdictions and what domestic courts can do. So I think it's great that you have a panel talking about universal jurisdiction because it is really the purview of domestic courts. And I will say, why am I talking about universal jurisdiction in the United States? Well, one, it's the jurisdiction I'm most familiar with. But two, it's a place that people often look to for accountability for human rights abuses and atrocity crimes, because many people find themselves there and can be subject to the personal jurisdiction of U.S. courts. And of course, many assets are located there. Many corporations, even if they're foreign corporations, if they're multinational corporations, they often have U.S. subsidiaries or some aspect of their action hits the United States in some way. Okay, so I do want to talk a little bit about, again, where does universal jurisdiction kind of fit in the scheme of possible bases of jurisdiction? The first and strongest and by far most often applied is territoriality. And here we're talking about jurisdiction to prescribe, which is a nation's ability to make its law applicable to persons or conduct, relations, interest, prescriptive jurisdiction. So territoriality, as I said, is really the first and strongest and typical way that we think about jurisdiction. And there are these others, nationality, or sometimes called active personality, which is conduct performed by the country's nationals wherever it occurs. Passive personality, where you have the country's nationals as its victims. The protective principle. All of these are founded or require some kind of connection, even if it's minimal, some nexus to the foreign country. Universal jurisdiction, which allows for jurisdiction when the conduct is recognized by the community of nations as of being of universal concern. Universal jurisdiction, of course, is the one base of jurisdiction where that nexus is severed. And as Gurgen mentioned, I believe, this sort of idea of pure universal jurisdiction where there doesn't need to be any connection whatsoever to the foreign state. This is, I think, for most, if not all nations, somewhat of an uncomfortable idea, somewhat to maybe very uncomfortable idea. And the reason for that is because I think it really gets back to this principle of sovereignty, which underlies all of international law and really international relations. This is such a bedrock principle in international law, sovereignty, the idea that each individual nation has full sovereignty over what happens within its own borders. And so in classic international law, it really has no interest or anything really to say about what happens within a country's own borders. That is not traditionally the purview of international law, and that principle still really animates international law. We have had since World War II a real very strong growth in bodies of international law that have eroded or chipped away at sort of full sovereignty. And the rise of human rights law is one of the primary areas. So we see the passage of the International Covenant on Civil and Political Rights and Economic and Social Rights and numerous other human rights treaties that do talk about and regulate in various ways the conduct of states toward their own nationals. So conduct that does occur within a state's borders has now become part of international law. But it's really, if you think about it, a very new development, something really only in the last, 50, 60, maybe 70 years. And so states are still very reluctant to intrude on what they see as affairs of other states. And I think this is a crucial principle to understand why universal jurisdiction, why many states are reluctant to legislate for universal jurisdiction, and why many prosecutors are reluctant to file universal jurisdiction cases. Okay. So Maria mentioned the crimes that are subject to universal jurisdiction. It's a very small group, really. Most, I think all of these are what can be called jus cogens norms, norms in international law that are applicable to all nations and from which no derogation is permitted, even by treaty. It's a very small group of core international crimes. Okay, so what does universal jurisdiction look like in practice? And again, here we have the two sort of paradigmatic cases establishing universal jurisdiction for atrocity crimes. You have on the bottom here, this is a picture of Adolf Eichmann. This was the first use of universal jurisdiction to prosecute an atrocity crime. This was in Israel in 1961. And this case at the time that it occurred was controversial for a number of reasons, not least because of the way in which Eichmann came before the personal jurisdiction of Israeli courts. He was abducted from Argentina, where he had been living after the World War II, smuggled out of the country to Israel in a secret Mossad operation that was unknown even to Argentina. So this was a major violation of Argentine sovereignty. But I think Israel undertook this operation because they had reached the conclusion that neither Argentina nor Germany was willing to prosecute him for his central role in perpetrating the Holocaust. And Eichmann, of course, was the primary organizer of the Nazis' final solution. He brutally, efficiently coordinated and administered the identification, assembly, and transport of millions of Jews from occupied Europe to the Nazi death camps. So he was charged with several atrocity crimes, and Israeli courts asserted universal jurisdiction, which, in the words of the Israeli Supreme Court, the international character of crimes against humanity, in the very wide meaning of the term dealt with in this case, is no longer in doubt, because the basic reason for which international law recognizes the right of each state to exercise such jurisdiction, universal jurisdiction, traditionally grounded in piracy offenses, piracy being a crime committed on the high seas, over which no state had any form of territorial jurisdiction. So the Israeli Supreme Court said, well, look, these kinds of crimes that Eichmann committed bears the same characteristics as piracy, and in fact applies with even greater force. And so there is no reason that universal jurisdiction should not be applied in this case. And so that reasoning has really become emblematic. This case has become emblematic for when universal jurisdiction is appropriate in domestic courts. Then we have also the case of Augusto Pinochet, which was also mentioned, a case in the UK, Pinochet being the former Chilean dictator. He was accused of crimes against humanity and torture. Spanish courts issued an arrest warrant for him under universal jurisdiction, and the authorities in London arrested him. There was a case whether he could be extradited to Spain, and actually the UK courts rejected his assertions of immunity. He argued that as a former head of state, he had absolute immunity and couldn't be prosecuted. UK courts rejected it. They authorized the extradition. Ultimately, he was not extradited because he was found unfit to stand trial. But the case also illustrates, again, the circumstances in which domestic courts may be willing to exercise universal jurisdiction, and also refers to something that Gurgen mentioned, which is potential immunity for the leaders, the senior political and military leaders that are typically the ones that formulate the policy and issue the orders that result in atrocities. Those are the people that often we really want to see held accountable. But those people, particularly the head of state, enjoy certain immunities from prosecution while they are in office, in international law, certainly, and typically in domestic law as well. And so there are questions about whether that immunity can be waived or whether it extends past the person's time in office. And indeed, if even the commission of atrocities is legitimate action of a government official. And so even while they are in office, whether that immunity can be abrogated. That was the case, for example, with Charles Taylor in Liberia. But these are serious questions, and courts are reluctant to really find that these sort of bedrock principles are not applicable, particularly when you're talking about universal jurisdiction and there's really no nexus to the forum state. Okay. So universal jurisdiction in the US. As was mentioned, there has to be some legislation, authorizing legislation. There is such legislation in the US with respect to certain crimes, but they do require that the person be present in the US. So that is the case with the criminal genocide statute. It is the case with the piracy statute. The person must be brought into or found in the US. That's the same with the torture statute. And it is the same with the war crime statute, which also applies incidentally to members of the US Armed Forces. A Crimes Against Humanity statute was introduced in the Senate in 2009, but never passed. Hopefully will be reintroduced again at some point. And then there are certain obligations pursuant to treaty. So does the U.S. actually prosecute universal jurisdiction crimes? This is a little bit of a mixed bag. There are no genocide prosecutions in the U.S. as far as I'm aware. Maybe somebody knows of one. There have been piracy prosecutions, although many of those cases are from the 1800s. Torture, again, as mentioned, now we have the Torture Victim Protection Act. You do sometimes have this immunity from prosecution issue, but there have been several successful cases. And this is, of course, a civil action. So we're not talking about prosecution. Same as for war crimes, often filed as private civil actions under the Alien Tort Statute, although that, again, is now limited under Kayabel, not only for actions that touch and concern the United States, but it's been narrowed even more in a series of Supreme Court cases, such that at this point now the standard for the ATS, even for civil liability in the U.S., is very strict. It really requires that the action, the wrong that is alleged to have occurred, not just be, for example, in the case of a corporation, sort of planned or directed from the United States, but it really requires that there be some overt action in furtherance of the wrong, the crime that that occurred in the United States. So it's a very high and difficult standard to meet at this stage. Something that many people don't know about is that the Department of Justice has, since 1979, something called the Office of Special Investigations, also colloquially known as the Nazi hunters. That office was active from 1979 to 2010. In 2010, it transitioned to become the Human Rights and Special Prosecutions section of the DOJ. And that office actually is the office that is tasked with finding and locating people within the United States that are perpetrators or alleged perpetrators of atrocity crimes anywhere around the world. So they started out as Nazi hunters. Its mandate has been expanded to prosecute human rights violators from anywhere in the world. They have prosecution over crimes including torture, war crimes, genocide, female genital mutilation, and recruitment or use of child soldiers. What they typically do, though, is they prosecute civil and criminal immigration fraud. And this was the blueprint that was established when it was still the OSI. So they would find former Nazis, often prison guards, members of auxiliary police forces.
Rajika, I'm so sorry to interrupt. Our time is a bit short, so I wanted to move on to the Q&A session, if that's all right.
Sure. Yes. Let me, I think if I could just talk briefly, there's a couple of points on my last slide that I think I want to just mention quickly.
Sure. Yes, we can go through the last slide.
Okay. So I think looking at the future of universal jurisdiction prosecutions in the U.S., as I was saying, I think denaturalization and removal proceedings, immigration proceedings, are one way, and that will continue. There is also a movement toward conflict-specific legislation that has happened in a way with respect to Syria. There's no explicit authorization for universal jurisdiction, but there's language in this legislation that requires the US government to report on actions it's taking to find accountability that could perhaps lead to universal jurisdiction. And then I think there's action to strengthen prevention efforts. The Elie Wiesel Genocide and Atrocities Prevention Act puts additional training into the front end and additional State Department resources into the front end. So I think what I just want to conclude with is to say that I think federal legislation is a strong place to look at if you want to pursue universal jurisdiction prosecutions in US courts. Find ways to frame issues that can attract bipartisan support in Congress. You know, I think that would be the strongest way to signal that this is something the US is open to doing. So I'll end there. Thank you very much.
Thank you so much, Rajika. We're going to have a short Q&A session, and then at 11:40, we'll go downstairs to hear Mr. Arman Tatoyan. So my first question is going to be for Ms. Armoudian. Regarding the alteration of the U.S. legislation war crime statute, is it possible it will be written to be limited just to crimes committed in Ukraine? That the courts will interpret it to be limited?
I think it's really hard to say because it's in development right now. I sort of doubt it, but they will probably put some limitations on it just because the U.S. is one of those countries that is a little bit hypocritical in terms of, you know, wanting to avoid prosecution themselves. And so I think there will be some limitations, but I don't know. I don't think they could do it they could, but I don't think they will do it just for Ukraine. So, you know, it's a good time to practice advocacy and to lobby and to try to make sure that we get what we need into that legislation. It's something that probably all of the Armenian lobbying organizations should get involved in.
Thank you. And next question is to Dr. Gurgen Petrossian. What is the risk or opportunity balance for Armenia to sign the Rome Statute and submit it to the jurisdiction of the ICC?
What is the risk? I don't see any risk at this moment. Of course, we have to, as a outsider, let's say, from the government should make, of course, a balance to see what may happen in the future, because there is a moment when the state is entering or is getting member to the ICC, there is no retroactivity, so that may not be used for the past cases, as long as it does not accept this kind of jurisdiction. But I see that at this moment, from my side, as an expert in ICL, I wouldn't say that I see risks for the future, because as soon as Armenia also acknowledges that it will respect the Rome Statute.
Thank you, Dr. Petrossian. In follow-up to that, if no Rome Statute ratification, should the Armenians push for Armenia or Artsakh to send a declaration to the ICC to refer to the situation, or should the ICC member states be pushed to refer a situation in accordance with Article 4 of the Rome Statute?
Yeah, this is a good question. I think pushing other states is connected to the good diplomacy and also interests of diplomatic relationship, how good the other member states of the Rome Statute are good connected diplomatically to Armenia. This is, of course, another political issue and diplomatic issue, but state referral by the Republic of Artsakh or Republic of Armenia is, of course, possible.
Okay, thank you, Dr. Petrossian. Next question is for Rajika Shah. Does the U.S. justice system have a real interest in applying international jurisdiction, or does it usually reject legal claims on universal jurisdiction?
Thank you for the question. I think what I would say is it's really what we're talking about is a matter of prosecutorial discretion. And so, the reasons why federal prosecutors in the US are reluctant to file these cases, well, you can have that conversation. I do think that it gets back to some of the foreign policy concerns that were spelled out in other presentations. There's a strong deference to the political branches, the legislative, the executive. Courts are very concerned about, as the Supreme Court put it in Kayabel, the danger of unwarranted judicial interference in the conduct of foreign policy. And, really extraterritorial application of U.S. law, I think, animates a lot of the prosecutorial decisions. I also think that there's a strong concern about reciprocity, frankly. U.S. authorities are well aware that there are many, many people around the world who would be very happy to hold U.S. authorities accountable for some of the actions that they have undertaken overseas. And so they really want to foreclose that opportunity as much as possible. So I think those are some of the underlying animating concerns behind this reluctance to file.
Thank you so much. Ms. Armoudian, the next question is for you. It was mentioned that there have been many TVPA success stories, but in the research of the question writer suggests that that's not so clear. And for one thing, even if able to get a judgment enforcement and putting it into the hands of the victims is very hard. That's okay. Is the expressive value of a judgment enough?
Well, that sort of depends on the victim, right? It is very hard to collect. And in most cases, even when they win judgments, it's very difficult to collect, and they can sometimes get a small fraction of the judgment that they have won. I think the NGOs that are the best on this are the CJA, the Center for Justice and Accountability, and CCR, Center for Constitutional Rights in the United States. They've been the ones that have been mostly doing those cases. And I think the CJA has won almost all of their cases. They have pro bono counsel, usually with Morrison Forster, which is a big law firm. And I do think the biggest issue is collection, but a lot of the survivors, even if they don't collect money, do at least feel like that acknowledgement has mattered, and it's something that can then lead to something else. It is a legal thing. Often if the perpetrator happens to be in the country, they can get deported. Sometimes they can get prosecuted after that because you've got this documentary trail that you can use for other judicial activities. So I think there was another piece I was going to say, but I've forgotten it. Was there anything else on there?
I think the last part of the question was whether expressive value of a judgment is enough.
And I think the survivors who bring the cases are the ones that question has to go to. I do know that for many of the people who have survived something like torture or massacres, one of the main things is, you completely lose agency, right? And there's something about the litigation process in which they are bringing the suit. This is different from a prosecution. It's where they are suing somebody for the torture or for the other human rights violations. And so they're getting their agency back. And that's something else that should they be able to withstand the entire process of litigation, can also be very psychologically healing.
Thank you so much. We'll end with one last question for Dr. Petrossian. Will the German war crime cases require an analysis of the Geneva Convention Article 3 to determine if the Artsakh War was a non-international or international armed conflict? What is your position on this?
Yeah, you know the position of Germany in this particular situation, and they consider it as an international conflict. The prosecutor, in response to our submission, they categorize that the conflict is international conflict. And about Artsakh, this is my question. My answer. Sorry.
Thank you. At this time, we're going to end this panel. I want to thank all of the panelists. It was a very informative session. I learned so much from each of them, so I thank all of them, and thank you to the audience today.